All right, cool. All right, so my name's Chris Berry with Castle Wealth, your certified financial planner, certified law attorney. And every Wednesday at 1 o'clock, we talk legal, financial, and tax planning, answering whatever questions you may have or whatever's going on in the world. And we always start with a positive focus, just something positive that hope it happened over the past week. And I will share that today's positive focus is that it's Star Wars Day. So I'm a big Star Wars nerd, so it's May 4th. So may the 4th be with everyone. With that, we'll go ahead and get started. And again, if you do have a question, please put it in the Q&A so we can go ahead and address it live on the Zoom today. And I think I only have one question that was submitted ahead of time. Oh, here's into the chat. And may the 4th be with you as well. I like it. All right, let me share my screen. Guess another positive focus. There's the Obi-Wan Kenobi series coming out, I think May 27th. So my family and I were really excited for that one. But, all right, that's not why you're here. All right, so again, this is general information. If you want to see how this applies to your situation, make sure to schedule some time on my calendar. And with that, our first and really only question that was submitted ahead of time, it's a good one. We'll have to kind of talk about what it means here, but the question goes like this. So Ed Slott, and I'm a big fan of Ed Slott. He's thought of as America's CPA. I've participated in his elite advisor training program where we'd meet 3 times a year, get like 400-page binders of all the different things that's new in the IRA world. And so Ed Slott and his team recommends not naming the trust as your beneficiary for your retirement accounts. Can you explain your take on it? So yeah, I remember kind of as I was at Ed Slott events and him talking about this, and understand just first his role. His role is a CPA. So he's really looking at this from a tax perspective, and he's looking at it from a perspective of people screw things up a lot. And so the issue is we have these, we call them qualified accounts like IRAs, 401ks, 403bs. And let's for now just focus on them being pre-tax, meaning you haven't paid any income tax. And so what would happen is that when you turn 70 and a half, you would have to start paying taxes. You'd have to start taking out what's called required minimum distributions, okay, RMDs. And so now you would have to take out a portion and pay the taxes at some point. Well, then the Secure Act was passed, and it actually pushed back the RMD age from 70 and a half to 72. Whoops, not 27, 72. So now you have to start taking out RMDs at age 72. And actually right now, past the House, we have Secure Act version 2, which is saying now your RMDs are going to be at age 75. This isn't law yet, but this is probably where we're going to be. But that's not why Ed Slott says not to name the trust as beneficiary. So like with the IRAs, typically what we do, and same with 401ks, 403bs, is you're the owner. You have to be the owner. Has to be you. Can't be anyone else. All right. Then primary beneficiary. So if you were to pass away, typically we would have the primary beneficiary be a spouse, because then you could do what's called a spousal rollover. And then the contingent beneficiary. And so this is where Ed Slott and myself differ. And I'm comfortable with that. And I'll tell you why. We typically recommend, when we're doing documents and planning for our clients, we typically recommend naming the trust as the contingent beneficiary, okay? And I'll get into why. But here's the thing. So prior to the Secure Act, when we named someone other than a spouse as a beneficiary of the IRA, they could do what's called a stretch IRA. So they could stretch out the taxes over their lifetime. So if you left like a pre-tax IRA to a 10-year-old, their RMD, because they would have a required minimum distribution, might be like 1%, and it could grow at 3% or 4% or 5%. So the RMDs, you're almost creating this like lifetime income stream for your beneficiaries if they're young enough inheriting these IRAs. So we would do like a lot of stretch IRA trusts, in fact. But what the Secure Act said is no more stretch. Instead, all the taxes have to be paid within 10 years. Okay. So that's kind of the current law. Now, here's the thing. And this is why Ed Slott would say, don't name a trust as the beneficiary. Because to get that stretch that we used to have, it had to be what's called a designated beneficiary. And this is kind of dry tax stuff. But I just want to clarify why I actually differ from Ed Slott on this, and Ed Slott's a lot more famous than me. It has to qualify as a designated beneficiary to get that full stretch. And guess what? Some trusts may not qualify as a designated beneficiary. And if that's the case, all the taxes have to be paid within 5 years. So you're looking at naming a designated beneficiary for full stretch, or if it's not a designated beneficiary, all the taxes have to be paid within 5 years. So his concern is there's a lot of attorneys out there doing trusts that don't understand this, or a lot of advisors that don't really understand this. So his concern is if you don't have a well-drafted trust, then all the taxes would have to be paid within 5 years because the trust didn't qualify as a designated beneficiary. Well, here's why I say that's fine, but in our practice, we're naming the trust as a beneficiary because our trust always qualified as a designated beneficiary because of the language that we include in there and because we avoid some of the pitfalls. So we were doing, prior to the Secure Act, we were doing stretch IRAs, specifically doing a specific trust for the IRA to stretch it for like grandkids. But even our trusts now, they all qualify as designated beneficiaries. So we still get the full 10-year stretch that is allowed as a designated beneficiary, whether you name someone individually or you name the trust. With our trusts, at least, it qualifies as a designated beneficiary, so you get the full stretch. So that's why we include an article, and I was a minute too late because I was reviewing an estate plan with clients. They're just signing a castle trust, and one of the articles, Article 10, was talking about retirement accounts and being able to stretch out the full 10 years. So that's why Ed Slott does not recommend naming the trust, is because he looks at it from the tax perspective, and he sees, and people go to him with like a lot of the problems or screw ups. And so there's a lot of times that the trusts don't have the necessary language to be able to stretch it out the full amount, which now is 10 years thanks to the Secure Act. So he was just being conservative, knowing that there's good attorneys and bad attorneys and good trusts and bad trusts. And so his generality is to say, you know what, it's not worth naming the trust. And then the other reason why it's really important to name the trust, typically with a lot of our trusts, is because our trusts don't always say it goes just outright to the beneficiary. If that's the case, you can name the beneficiary as a beneficiary designation. What a lot of our trusts do, especially our legacy and castle trusts, is we build in the opportunity for a lifetime of asset protection for our beneficiaries. So whatever they inherit are protected from divorces, creditors, bankruptcies, and then whatever they keep inside of the trust would flow down to your grandkids versus going to in-laws. That's very different than naming your child outright on your IRA. So that's the big reason why, even though we can only stretch it 10 years now, we still name the trust as the beneficiary. And worst case, the IRA, the taxes are paid, but the proceeds could still remain in the trust. So there's a very beneficial reason why we name our trust as a beneficiary of the IRA, because we give this opportunity for a lifetime of asset protection to the beneficiaries. You name the child outright on the IRA, they're going to lose that. And then the reason why Ed Slott, the CPA, America's CPA, who's been on PBS, says don't name a trust or have second thoughts about the trust, is because he's seen too many situations where attorney either isn't aware or doesn't include the language inside of the trust to get that full stretch. So now the full stretch, whether you name a person individually or you name a trust, is just 10 years. But with our trusts, they do qualify as designated beneficiaries, so they still get the full 10-year stretch. So yeah, it's something I remember when I was in his training a number of years ago, and he's kind of started mentioning that and mentioned, I was like, oh, my ears perked up, because we were always naming since 2004, 2005, we've been naming the trust as a beneficiary. But it's just because our trusts include the language to qualify as see-through or as a designated beneficiary. And he saw a lot of situations where people weren't doing that at the time. So that's why kind of his blanket statement is we don't name the trust as a beneficiary. But when you, again, you have to be careful listening to like generalized advice, especially from like the celebrities. And I'm a big Ed Slott fan. I'm not trying to put him down by any means, but it's just that, like, as long as you know the pitfalls to avoid, it's perfectly fine. In fact, beneficial 9 times out of 10 to name the trust as beneficiary of the IRAs. Here's another question. So hopefully that was helpful with regards to naming the trust as beneficiary of IRAs. So we almost always do spouse first and then trust as contingent beneficiary. Here's a question that came in. Let me just copy it and I'll open it up into another document so I can share it. Give me a second here, click this button, and all right. So here is, what is that? All right, so here's the question that just came in. What are the advantages or disadvantages of setting up dynasty trusts? My understanding is that these are out of the estate total amount. Yeah, so we just have to be careful with naming trusts, because I might, like, one attorney might call a trust one thing, another attorney might call the same trust something else. So what I'm guessing is that this is some type of a form of irrevocable trust. And I'm guessing the purpose of this is for estate tax purposes. So right now, the estate tax exemption is at $12 million. Meaning you can pass away, and as long as you pass away with less than $12 million, you owe 0 estate tax. Anything more than $12 million, you're going to owe an estate tax. Now, the interesting thing is that this $12 million exemption is going to, adjusted for inflation, we'll call it $6 million in 2025. So the interesting thing here is that, okay, we'll get to that. Yep. All right, another question came in. So $12 million is going to $6 million in 2025. And this is the estate tax exemption. Now, the interesting thing is this estate tax exemption is also your lifetime gift tax exemption. Okay. So they're tied together. It's called the unified credit. So during your lifetime, you can give away, or upon your death, up to $12 million estate tax free. And it's actually doubled if you're married. So here's a strategy, and maybe this is what you're getting at, is, okay, right now, 2022, I have a $12 million exemption, right? What if I give away $5 million in 2023, right? How much does that leave me? I can't do math in my head, but that leaves seven. Well, actually, we want to give away more. So let's say we give away $6 million in 2023 to the Dynasty Trust, which has to be in a separate tax ID. You have to give up a lot of control. And I assume this is what you're referring to with the Dynasty Trust. So now maybe the kids are in control or something like that, or you have an independent trustee. But what you've done is you've removed it from the estate. Now 2025 comes around, and now you're left with a $6 million exemption. And then let's say you pass. Well, guess what? You're using your $6 million exemption, so there's 0 estate tax. So what's happened is when the estate tax exemption dropped from, was still at 12 million, because it's a unified credit with the lifetime gift tax, you can make a $6 million gift to a trust. And then even though the estate tax exemption drops, basically that gift you made, what the larger cap was grandfathered in. So I think that's what you're trying to get at with this idea of moving it out of the estate into a irrevocable trust. And yeah, so if you're willing to give up that control for the estate tax, less estate taxes, that makes sense. And there's different strategies if you do have an estate tax, whether you can look at charitable strategies, but yeah, removing money from the estate now while the Tax Cuts and Jobs Act runs from now to 2026, that certainly makes a lot of sense. You just have to give up control. That's what you're dealing with whenever you're doing estate tax planning is, okay, we have to give up control. Versus here, someone's asking, and I'll write this one down. All right, so someone's asking about a castle trust. So let me run through that. So this is a different type of trust. So this is kind of how a castle trust works. So say you have your assets here, or this is the two of you, you're married, you have your assets, your investments, businesses, real estate, etc. If you're to just move this money into your basic revocable trust and fund the trust, understand you're not protecting against two potential catastrophes. One would be lawsuits, and then the other one is long-term care costs, more specifically the $8 to $12, $13, $14, $15,000 a month nursing home bill. So, hold on. Yep. And so the question is, what are the exact mechanics of the castle trust for complete liquidity and access to assets for grantor yet full protection? Okay. So what we do is we set up a asset protection trust. We call it a castle trust. Okay. Now you move the assets into the trust. We have things like your home, your cash, your investments, whatever businesses, your LLCs, your second pieces of real estate, all of this goes into the trust. And now it's immediately shielded from lawsuits. And then also what it does is starts a Medicaid race where if you can make it 5 years before you need a nursing home, then everything inside of the trust is protected from that nursing home or Medicaid spend down. Where now we wave a green flag as the assets move into the trust to start the race. And then once we make it 5 years, we can wave the checkered flag because now 100% of what's in the trust is protected from that nursing home or Medicaid spend down. So now we can have Medicaid pay that base level care, pot of resources available to pay for additional services. So the question is like, what are the mechanics or how does this work? Well, this is a form of irrevocable trust, but it's a grantor trust. It's not affected from, it's not removed from your estate. We wouldn't do this for estate tax planning. What we're doing this for is lawsuit protection and long-term care protection. And so this was exactly the reasons why we did it with clients right before I walked in here, is they wanted to protect themselves from lawsuits, long-term care costs. They owned a business. They worked hard for everything they had, and they didn't want to see it lost to a silly, frivolous lawsuit, or if they were to need nursing home care in the future. And so what we've done is we basically created a castle trust, an irrevocable trust that follows a lot of the same format of the revocable trust, but still offers the asset protection. So if I were to compare the revocable trust versus the castle trust, like let's compare how it works in terms of income, who can serve as trustees, changing beneficiaries, getting assets out of the trust, protection from long-term care, protection from lawsuits. So we set up the revocable trust, you pay income tax the way you normally do. With the castle trust, same, you pay income tax the way you normally do. It's still a grantor trust, still in your name. With a revocable trust, you can change trustees at any time and you're the trustee. Same with the castle trust. So you're the trustee. So you have, you can sell your home and turn it to cash. You can turn your cash into a new home. You can buy and sell, go from Google stock to Apple stock, you're in control. With a revocable trust, you can change beneficiaries at any time. Same with the castle trust, you can change beneficiaries at any time. With the castle trust, you can empty the trust at any time. Same with the castle trust, you can empty the trust anytime. There is one extra step where basically you take the money out of the trust, you move it to what we call a key holder account. And then from that key holder account, then the money can be moved back into your name. And so for that one little difference, what does that get you? Does a revocable trust protect you from lawsuits or long-term care costs? The answer is no. Does a castle trust protect you from those things? The answer is yes. So for that one little difference, that's what builds in the additional benefits. So what we did is we made an irrevocable trust that you can change beneficiaries, you can change trustees, you can manage. A little more complicated on how we get money out of the trust, but for that one little change, that's what builds in the additional asset protection. Another question here on the Castle Trust: can a Roth IRA go into the Castle Trust before or after the owner's death? So let's say you had a Roth IRA. Well, what you could do is you could take the money out of the Roth and then just put it into a trust account, and there's no taxable consequence of that. So if you wanted the asset protection, you just pull the money from the Roth, no taxes are due, invest it in the trust. And even if you liked what it was invested in the Roth, you could do the same thing with the trust. So if you had XYZ in your Roth, you could do XYZ in the trust. Or you can just name the trust as, so if you have a Roth, you could name primary beneficiary spouse, and then contingent beneficiary could be the trust. Okay. So yeah, you can take the money out of the Roth to put it into the trust, or you can name the trust as a beneficiary. The bigger issue is with IRAs. You have to pay the tax to move the IRAs in, but with taxes going up, typically it makes a lot of sense to do that in the first place. All right. Question: does the Castle Trust also offer legacy inheritance protection for the kids? Yeah. So not only is it protecting you from creditors, lawsuits, long-term care costs, but then when you pass away, we can build in those same protections for the kids. So if you had 3 kids, your one Castle Trust or one Revocable Trust, either way, can split into 3 separate shares, 1 share for each child, and then each child would basically be inheriting almost like a mini Castle Trust, where whatever they decide to keep in the trust would be protected from divorces, creditors, bankruptcies. And then if they were to pass away, the money would flow, would go down to, say, your grandchildren, if that was the way that the plan was designed. So again, the idea is that you worked really hard for whatever it is you have, and so let's protect it. Like I was having a conversation with the client earlier today, and we're talking about the markets, and he was forced to retire from Ford and looked around and is like, I don't realize how much or how I save so much money. And so he was sitting on a couple million, and we're talking about how he didn't want to lose it now, that now he's moved from the accumulation phase where it's just I'm working to now it's preservation distribution phase. And then with his current advisors, they were just telling him like, oh, let's just keep moving with the same plan. But now he's looking at it as, okay, I put all my life's work and I'm not working anymore, and I put in thousands of hours, and that's really what the money that you've accumulated is. It's the thousands and thousands of hours of work that you put in. He didn't want to see that lose now to the market. And so similarly, that's what we're doing with the Castle Trust, is all this effort and time and your legacy, we don't want to see that lost to lawsuits, creditors, or long-term care costs. So that's why we really focus on this preservation of assets and potential distribution. So, all right. Any other questions? If you have questions, please put it in the Q&A. Otherwise, I think I have answered. All right, cool. All right, so happy May 4th. May the 4th be with you. Happy Star Wars Day. Thank you for the questions. I appreciate it. And we'll see you next week. And if you do have further questions, thanks. You're welcome. Please just shoot us an email and we'll answer them on the next call. So see you next week. Take care. Bye-bye. Bye. Make it a great